Hi, very good evening to all of you. So నిన్న మనం సగం వరకు చెప్పాం కదా. So today we will discuss about the High Court and Supreme Court writ jurisdiction. Okay. And second we will discuss about the types of writs. Okay. And case laws also. Good. And third we will discuss about the, if time permits, doctrine of basic structure and origin. Why it is origin? Actually, doctrine of basic structure, it is given by a famous German scholar. Okay, we will discuss about it because there are two type of laws, common law and constitution. So we will discuss about it. Before jumping into those nuances, just understand the first concept. What is the High Court? Why High Court has wider jurisdiction than Supreme Court? So ఒకటే చెప్తా, గుర్తుపెట్టుకోండి. So these classes are to understand, to make you to understand the concept why. Okay, the basic fulcrum to understand any topic. So High Court has wider jurisdiction than Supreme Court. ఫటాఫట్ ఖతం ఒక లైన్లో అయిపోయింది. But if you understand why it is High Court has wider jurisdiction than Supreme Court, then your real preparation, that is your real preparation. Okay, so that you able to answer the mains question in very coherent manner. Good, right? First one, let's. Why High Court has wider jurisdiction than Supreme Court? Right? Suppose మీ అందరికీ తెలిసి ఉండొచ్చు, we have fundamental rights, we have constitutional rights, we have also statutory rights or legal rights. Fundamental rights, any right under Part-3 of Constitution. Example 21, right to life. Okay. Constitutional right is any right given under the Constitution except fundamental right. Okay. ఏ కాన్స్టిట్యూషన్లో చెప్పండి, ఏ రైట్ అయినా కాన్స్టిట్యూషనల్ రైట్, బట్ Part-3 తప్పించి. ఓకే. ఎగ్జాంపుల్ 300A ఆర్టికల్, రైట్ టు ప్రాపర్టీ. గుడ్. Statutory right or legal right is the right given by the law. Okay. Example RTI. Okay. Right. Next example, Consumer Protection Act. Consumer Protection Act. Okay. Consumer Protection Act. Good. So now you can understand this. In case article fundamental right is violated, fundamental right violated, you have two ways, Supreme Court or High Court. In case your constitutional right is violated, then you have High Court, then on appeal you can go to Supreme Court. It is original jurisdiction, exclusive jurisdiction, it is appellate jurisdiction, because you are going on appeal only. In case of statutory rights or legal rights, you can first move to High Court, then move to Supreme Court. Suppose if there is an alternative remedy, then you can, in these two cases, if there is an alternatives legal remedies, then first you can go to that alternative channel. Good. I hope it is clear to you. In case of fundamental right, you can go to Supreme Court, you can go to High Court. In case of constitutional right, you can move to High Court first, then you can move to Supreme Court on appeal. If there is an alternative remedy, then you can move to first alternative, then on appeal you can move to High Court, then on appeal you can move to Supreme Court. So High Court has wider jurisdiction than Supreme Court, because High Court can enforce your constitutional rights, High Court can enforce your statutory or legal rights, High Court can also enforce your fundamental rights. Fine. That's why High Court has wider jurisdiction than Supreme Court. You can see this in this. You can see. I hope it is visible to you. Yeah. Article 32. Article 32. Remedies for the enforcement of rights by this part. Part 3 means this part means part 3, that is fundamental right part. You can see this. Supreme Court, Article 32, Clause 2. Supreme Court have power issue. Em issue chestadante directions can issue, orders can issue, writs can issue. Writs include habeas writ, mandamus writ, prohibition, quo warranto, certiorari for enforcement of any right conferred by this part, means part 3, fundamental rights. So fundamental rights violation జరిగినప్పుడు సుప్రీం కోర్ట్ ఆర్టికల్ 32 ఏం చెప్తుందంటే సుప్రీం కోర్టుకి పవర్స్ ఉంటాయి. ఏం పవర్స్? పవర్ టు ఇష్యూ డైరెక్షన్ అన్న ఇష్యూ చేయొచ్చు, ఆర్డర్స్ అన్న ఇష్యూ చేయొచ్చు, రిట్స్ అన్న ఇష్యూ చేయొచ్చు. సో రిట్స్ కెన్ బి హెబియస్, mandamus, prohibition, quo warranto and certiorari. Now you can come to Article 226 of the High Court. Power to of High Court to issue certain writs. You can see this. Notwithstanding anything in Article 32. Article 30 లో ఏది ఉన్నప్పటికీ that mean this sentence means that. So every High Court, ప్రతి హై కోర్టుకి పవర్స్ ఉంటాయి. ఎక్కడ? త్రూ అవుట్ ది టెరిటరీ ఇన్ రిలేషన్ టు విచ్ ఎక్సర్సైజ్ ఇట్ జ్యూరిస్డిక్షన్. సపోజ్ ఏపీ హైకోర్టు ఉందనుకోండి, ఏపీ హైకోర్ట్ హ్యాస్ పవర్, టెరిటోరియల్ జ్యూరిస్డిక్షన్ ఈజ్ టోటల్ ఏపీ. టీఎస్ హైకోర్టు ఉంది, సో ఇట్ విల్ హ్యావ్ టెరిటోరియల్ జ్యూరిస్డిక్షన్ ఓవర్ తెలంగాణ. సపోజ్ కల్కటా హైకోర్టు ఉందనుకోండి, సో ఇట్ విల్ హ్యావ్ on the Calcutta, West Bengal, as well as also Andaman and Nicobar. Okay, good. So that is the territorial jurisdiction of the High Court. So it can issue to any person or any authority. Authority means executive, implementation body, including in appropriate cases government kuda ante ఆ టెరిటరీలోని గవర్నమెంట్. బట్ సపోజ్ ఏపీ హైకోర్ట్ కెన్ ఇష్యూ డైరెక్షన్స్ ఆర్ టు ద ఏపీ గవర్నమెంట్, నాట్ టు ద తెలంగాణ గవర్నమెంట్. ఓకే. ఆర్డర్స్ ఏమి ఇష్యూ చేయొచ్చు? డైరెక్షన్స్, ఆర్డర్స్, రిట్స్, ఇన్క్లూడింగ్ రిట్స్ ఇన్ ద నేచర్ ఆఫ్ హెబియస్, mandamus, prohibition, quo warranto, certiorari ఫర్ ఎనీ ఆఫ్ దెమ్. ఫర్ ది ఎన్ఫోర్స్మెంట్, దేనికోసం ఇష్యూ చేయొచ్చు? ఎన్ఫోర్స్మెంట్ ఆఫ్ రైట్స్ కన్ఫర్డ్ బై పార్ట్ 3. గుడ్. Part 3 as well as Part 3 and for any other purpose. You can see clearly Article 32 can says you can issue writ but to enforce fundamental rights only. So Article 226 says you can issue writs for Part 3 or for any other purpose. That's why High Court has territorial jurisdiction, wider jurisdiction, writ jurisdiction in comparison with Supreme Court. I hope it is clear to you now. Good, fine. So right. So now you can see Article 13, Article 32 and Article 226. So Article 32 Clause 2 says post constitutional laws means 26 Jan to 1950 తర్వాత చేయబడిన చట్టం ఏదైతే ఉంటుందో, ఇఫ్ ఇట్ ఈస్ వైలేటింగ్ టు ద ఫండమెంటల్ రైట్ అండ్ ఇట్ కెన్ బి డిక్లేర్డ్ యాజ్ అల్ట్రా వైర్స్. హౌ కెన్ ఏ లా కెన్ బి డిక్లేర్డ్ యాజ్ అల్ట్రా వైర్స్ ఆర్ హౌ కెన్ యూ స్టాప్ ఇంప్లిమెంటింగ్ ఏ అన్కాన్స్టిట్యూషనల్ లా? దెన్ these two will help to you. So these Article 13, 32 and 226, it forms a triangle to enforce or to enhance the concept of judicial review. Good? Fair enough? Fine. So this Article 13, 32 and 226. Article 13 ఏం చెప్తుందంటే పోస్ట్ కాన్స్టిట్యూషన్ లాస్ అంటే కాన్స్టిట్యూషన్ తర్వాత నుంచి వచ్చిన ఏ చట్టం కూడా ఓకే 32 ఫండమెంటల్ రైట్స్ని వైలేట్ చేయకూడదు. వైలేట్ చేస్తే దెన్ యూ కెన్ గో టు ద సుప్రీం కోర్ట్ ఆర్ యూ కెన్ గో టు ద హై కోర్ట్. సో నౌ అండర్ హై కోర్ట్, so now you went to the Supreme Court. So Supreme Court uses Article 32 and strike down that law. Good, right, fine. Now you can go to the, so under Article 32 and 226 you can go to Supreme Court or a High Court. Okay, now ఒక ఇష్యూ వచ్చింది, ఆ ఇష్యూని ఎలా రెక్టిఫై చేసుకోవాలి? సో దేర్ మస్ట్ బి ఏ రూట్, రైట్? సపోజ్ మీకు ఆకలిస్తుంది అనుకుందాం, యూ వెంట్ టు ద హోటల్, ఓకే, బట్ యూ నీడ్ సమ్ మెనూ కార్డ్ ఆల్సో సో దట్ యూ కెన్ నో ది అవైలబుల్ ఫుడ్ ఐటమ్స్. వితౌట్ దిస్ మెనూ కార్డ్ హౌ కెన్ యూ నో దట్? So now these Article 13 and 32 is like this hotel. Okay, your right is violated. You can go to the Supreme Court or you can go to the High Court. Absolutely fine. But how to use the Supreme Court and High Court so that you have some remedies, some channels. That is, first one is habeas corpus and second one is called mandamus writ. And third one is called prohibition, okay, and fourth one is called certiorari, okay, fifth one is called quo warranto. Okay, good, right? First you can see this one, fine. See, first suppose one night ఒక అర్ధరాత్రి ఒక పర్సన్ హీ ఈజ్ లివింగ్ ఇన్ హిజ్ హోమ్, ఓకే, ఆఫ్టర్ 10:30 a person standing in front of his door and knocking the door, tuck tuck tuck. So door వచ్చి ఓపెన్ చేశాడు, సో దట్ he arrested this person and took him to the jail. Okay, but BNSS says earlier, CRPC says whenever a person detained in police custody, he must be submitted before the magistrate within 24 hours except traveling time. సో ట్రావెలింగ్ టైం తీసేసి 24 అవర్స్లో మ్యాజిస్ట్రేట్ ముందు ఆయన ఎవరైతే అరెస్ట్ చేశారో ఆ అరెస్ట్ చేసిన పర్సన్ని నిలబెట్టారు. దట్స్ వై ద పోలీస్ యూజువల్లీ అరెస్ట్ ఫ్రైడే నైట్ సో దట్ దే కెన్ హ్యావ్ సాటర్డే అండ్ సండే యాజ్ అ హాలిడేస్, సో దే కెన్ హ్యావ్ గుడ్ టైమ్, 2 days of good time in their hands, so they can use their brute force and make the confession. Good. Suppose ఈ పర్సన్ని ట్యూస్డే అరెస్ట్ చేశారు. నౌ యాజ్ పర్ ది రూల్స్ BNS, you can submit this person Wednesday morning. So by Wednesday evening, by any case you can submit or you can produce before the magistrate. Suppose produce cheyaledu, what I can do, what this person can do, that is the fulcrum of habeas corpus. It means that you can produce the body means not dead body, produce the person before the court. Okay, good, fine. I will tell one example, recent example. One person from the Vijayawada, he was arrested. Later, he was beaten and custodial death. Okay, న్యూస్లో వచ్చిన ఆల్మోస్ట్ అందరూ చూసే ఉండొచ్చు. సో వై దిస్ కేస్? బికాస్ దిస్ కేస్ habeas corpus, you can produce that person before the court because the police is not producing that person. So it literally you are commanding, show me the person, bring the person before the court. ఇక్కడ మీరు ఇంకొక చిన్న ఎగ్జాంపుల్ చెప్తా. ఇక్కడ మీరు అందరు చూసి ఉండొచ్చు కదా జైబీ మూవీ. సో ఇన్ దట్ మూవీ ద కేస్ ఈజ్ ఆల్ అబౌట్ ది habeas corpus only, because habeas corpus commands the executive to produce the person before the court. Illegal detention, because illegal detention violates your article 21, right? Except article 22 enables the state to detention, preventive detention. Suppose ఈవెన్ ప్రివెంటెడ్ డిటెన్షన్ ఉన్న రీజన్ లేకపోతే ప్రివెంటెడ్ డిటెన్షన్కి రీజన్ లేకపోతే ఇప్పుడు సపోజ్ నేను ఉన్నానండి, నన్ను పోలీస్ వచ్చి ఎవరు అండర్ పీడీ యాక్ట్ కింద బుక్ చేస్తామంటే కుదరదు. పీడీ యాక్ట్ స్టేట్లో డిఫరెంట్ స్టేట్కి డిఫరెంట్. సపోజ్ ఆంధ్రాలో గూండాస్ యాక్ట్, తమిళనాడులో అయితే గూండాస్ యాక్ట్, ఓకే, రౌడీ షీటర్స్ యాక్ట్. సో ఇట్లాంటి ఛార్జ్ షీట్లు ఇలాంటి యాక్ట్స్ కింద బుక్ చేస్తే దెన్ ద పోలీస్ కెన్ కమ్ అండ్ ఈవెన్ దో నేనేం రాంగ్ కమిట్ చేయకపోయినా, ప్రెజెంట్ పాస్ట్లో నేను క్రైమ్స్ చేసి ఉండొచ్చు, ప్రెజెంట్ ఏ క్రైమ్ చేయనప్పుడు సో దే కెనాట్ అరెస్ట్ మీ బట్ దే కెన్ డిటైన్ మీ. సో ఇల్లు దట్టి బయటికి రాకు 24 hours 48 hours వరకు. ఇఫ్ యూ వైలేట్ దిస్ దే కెన్ అరెస్ట్ యూ. ఓకే, దట్ ఈస్ కాల్డ్ పీడీ యాక్ట్, ప్రివెంటివ్ డిటెన్షన్. And next second one is punitive detention. Punitive detention means I committed a crime, I murdered a person, so court made me guilty. సో నాకు శిక్ష చేసింది ఒక 7 సంవత్సరాలు 14 సంవత్సరాలు. సో ఈ 14 సంవత్సరాలు నేను జైల్లో ఉండాలి కదా. సో దట్ ఈస్ కాల్డ్ ప్యూనిటివ్ డిటెన్షన్. Punitive detention. This is called preventive detention because it is prevent to commit a crime. Punitive because already you did, that's why you were enjoying that sentence, detention, right? Good to go. So this is habeas, the famous case about the habeas corpus cases. This case, ADM Jabalpur versus Shivkant Shukla, also famous, one of the finest case in India regarding the habeas. See, you all aware that Indira Gandhi emergency period. సో ఈ ఎమర్జెన్సీ ఎందుకు వచ్చింది? బికాస్ దెర్ ఈస్ అ కేస్, బికాస్ ఇందిరా గాంధీ ఎలక్షన్కి సంబంధించి ఒక కేసు నడిచింది. దట్ వాజ్ కేస్ ఫైల్డ్ బై రాజ్ నారాయణ్. ద కేస్ ఈస్ కాల్డ్ అబౌట్ స్టేట్ ఆఫ్ ఉత్తరప్రదేశ్ వర్సెస్ రాజ్ నారాయణ్. State of Uttar Pradesh versus Raj Narayan case. So in this Raj Narayan case, the High Court of Uttar Pradesh cancelled the election of Indira Gandhi. So there is protest around India for her resignation. Okay, because she is legally not a prime minister, because her election was cancelled. But here lies the political game. So that time the president was Fakhruddin Ali. So she called the president Fakhruddin Ali and said that from today onwards I am imposing national emergency so that he can make the presidential order. So under Article 352 the president can impose the national emergency. So on that ground he imposed the national emergency because there was some kind of opposition uproar against the Indira Gandhi. So there were huge protests all over India because she is acting like a dictator almost. So one of the person Shivkant Shukla. Shivkant Shukla. Okay, right, fine. See, the case is interesting and you can see. So the Shivkant Shukla, this person also protested against the Indira Gandhi. So there was a that time there was a law that is called MISA Act. MISA Act means Maintenance of Internal Security Act. Because ప్రభుత్వానికి వ్యతిరేకంగా ఏదన్నా కార్యకలాపాలు చేస్తే దీని కింద తీసుకెళ్ళి జైల్లో వేస్తారు. సో నౌ యూ కెన్ ఆల్సో హ్యావ్ సమ్ కైండ్ ఆఫ్ లాస్. యూఏపీఏ యాక్ట్, టాడా లేదు ఇప్పుడు, ఒకప్పుడు ఉండేది. కాఫీ పోసా, ఓకే. దిస్ ఈజ్ ఎకనామిక్ అఫెన్సెస్ యాక్ట్కి సంబంధించి. దిస్ ఈజ్ టెర్రరిస్ట్ యాక్టివిటీస్, టెర్రరిస్ట్ డిస్రప్టివ్ యాక్ట్, ఓకే, టెర్రరిస్ట్ యాక్టివిటీస్. So now this is famously UAPA, Unlawful Activities Prevention Act. So sedition, Rajadroham, okay, acting against the Indian government or creating some kind of religious animosity among the people, okay, శత్రువులకి సమాచారం చేరవేయడం, స్పైయింగ్ ఆన్ ఇండియన్ గవర్నమెంట్, దీస్ ఆర్ కాల్డ్ అన్లాఫుల్ యాక్టివిటీస్. ఓకే, ఒకప్పుడు అట్లాంటిదే ఈ యాక్ట్ కూడా, మీసా, మెయింటెనెన్స్ ఆఫ్ ఇంటర్నల్ సెక్యూరిటీ యాక్ట్. సో దేశానికి వ్యతిరేకంగా కానీ గవర్నమెంట్కి వ్యతిరేకంగా ఏదన్నా తీసుకెళ్ళి జైల్లో పడేస్తారు. సో అండర్ దిస్ పర్సన్, బికాస్ హీ వాజ్ ప్రొటెస్టింగ్ అగైనెస్ట్ ద ఇందిరా గాంధీ అండ్ ద ప్రొటెస్ట్ బికమ్ హ్యూజ్ అండ్ హ్యూజ్. సో దట్స్ వై ద మీసా యాక్ట్ యూజ్ చేసింది గవర్నమెంట్. సో హీ వాజ్ అరెస్టెడ్. సో నౌ హీ with other persons who were arrested under the MISA Act, they approached the Supreme Court. Because you are arresting me means you are taking my life away from me. Article 21 is infringed, my right is infringed under Article 21. So they used Article 32 and went to the Supreme Court and said that because of this act, my Article 21 was violated. So now stop implementing this law and release these persons. Good? Fair enough? The case was decided by a 5-judge bench. Because constitutional bench is minimum 5 judges. Okay, highest is 15, Keshavananda Bharat, highest in India. Good. Now see, so the court, the state argued, this person Shivkant Shukla and others said, so these act arresting me just because I am protesting. So protest చేయడానికి నా రైట్ అదే. సో ప్రొటెస్ట్ చేసినందుకు they are arresting, they are making arrests, they are putting behind the bars. సో Article 21 violation. సో ఇక్కడ మీరు చూడండి, ఇట్స్ a famous case. The case was attended by the AG, Attorney General. Okay, so AG said that there's one of the notorious argument that was this right, Article 21, okay, given by the Constitution to you. Good, because it is a gift by the Constitution. So because it is a gift by the Constitution, or it is a gift of the state can take back from you. Fine, good logic. So I gave something to you, I have every demand to ask the favor back. Suppose నేను మీకు ఒక 100 రూపీస్ ఇచ్చానండి, ఫ్రీగానే ఇచ్చాను అనుకున్నాం. సో సపోజ్ టుమారో లేకపోతే ఒక 4-5 days తర్వాత నాకు ఒక 30 రూపీస్ 50 రూపీస్ కావాల్సి వచ్చాయి అనుకోండి. సో దట్ మై ఫస్ట్ థాట్ ఈజ్ యూ, బికాస్ ఐ ఫేవర్డ్ యూ వన్స్ అపాన్ ఎ టైమ్. సో నౌ ఐ హ్యావ్ సమ్ కైండ్ ఆఫ్ leverage to ask you. Good. So that's why the court argued this, the AG argued that because it is a gift of the state gave you the right to life, right? So now state can have every right to take it from you, so we are taking it. And the AG also argued, if under Article 352, if there is a national emergency is imposed, you cannot go to court under Article 21 violation. Famously, the court heard both arguments, and the Supreme Court 4:1 majority said that whenever there is Article 352, you cannot go to Supreme Court under Article 21 violation. But Supreme Court also said, Supreme Court is the protector of the Constitution. So there is right to move to the Supreme Court. Right to move to Supreme Court. But this right is not absolute. It can be cancelled under Article 352 in case of national emergency. That's why the 44th Amendment Act returned it. The 44th Amendment Act by the Janata government said that even under 352 is imposed, your Article 20 and 21 cannot be compromised. Now you understand why this 44th Amendment Act made this change. You understood this? Good. Fair. So the one judge, that judge was H.R. Khanna, the famous judge. You can Google about him. The H.R. Khanna, because he said that he rejected these argument, because so court cannot the national emergency ఉన్నప్పుడు వెనక్కి తీసుకోవడానికి లేదు. So he rejected all the argument and gave the dissent note. On the dissent note, he said that right to life and liberty is a natural right. Okay, exist independently of the Constitution. It means right to life and liberty అనేది నీకు పుట్టుకతోనే వచ్చిన natural right, because their nature has given this, not the Constitution. Even Constitution granted it or not, it doesn't matter, but because by birth you are a human, the nature gave this right to life. బతికే హక్కు, జీవించే హక్కు ప్రతి ఒక్కడికి ఉంది. అది కాన్స్టిట్యూషన్ ఇచ్చిందా ఇవ్వలేదా అని వస్తుంది. సో దట్ ఇట్ ఈస్ నాట్ ఎ గిఫ్ట్ ఆఫ్ ది కాన్స్టిట్యూషన్. సో ఇట్ ఈస్ నాట్ ఎ గిఫ్ట్ ఆఫ్ ది కాన్స్టిట్యూషన్, దెన్ హౌ కెన్ యూ టేక్ ఇట్ బ్యాక్? యూ కెనాట్ టేక్ ఇట్ బ్యాక్. ఈవెన్ ఆర్టికల్ 352 ఉన్నా సరే, దట్ ఈస్ ద హెచ్ఆర్ కన్నా ఆర్గ్యుమెంట్. బట్ ద కేస్ 4:1 డిటర్మైన్ దట్ ఆర్టికల్ 352 21లో 352 అమల్లో ఉన్నప్పుడు 21 యూజ్ చేయడానికి లేదు. ఓకే, గుడ్, ఫెయిర్ ఇనఫ్, గుడ్. నౌ సీ, సో 44th Amendment Act ఎందుకు వచ్చిందో అర్థమైంది కదా. సో దిస్ ఈజ్ టు రెక్టిఫై దిస్ జడ్జిమెంట్. ఓకే, నెక్స్ట్ సెకండ్ కేస్. Before that, I need to tell one concept. That concept is called sovereign immunity. Okay. sovereign immunity is similar to the rex is lex type, but not totally rex is lex type అని కూడా చెప్పలేం మనం, బట్ ఇట్ హ్యాస్ సమ్ కైండ్ ఆఫ్ ఫీచర్స్. ఐ విల్ టెల్ వన్ ఎగ్జాంపుల్. సపోజ్ దిస్ ఈజ్ అ పోలీస్ పర్సనల్. Good. This is another person Y. Police person X. అరెస్ట్ చేశాడు, పోలీస్ స్టేషన్లో పెట్టి కొట్టాడు. దిస్ పర్సన్ సకంబర్డ్ టు డెత్. నౌ కస్టోడియల్ డెత్, right? Now this person, Y person, suppose Mr. M, suppose father anukondi, okay? Now the father M case file chesadu. Now case evaru మీద file cheyali? You can file the police X, or he need to file on the state itself, because police is working for the state. Because if he is not working for the state, there is no need to torture him or he need to beat him. So Mr. M అనే పర్సన్ ఎవరి మీద కేసు ఫైల్ చేయాలి? పోలీస్ మీద కేసు ఫైల్ చేయాలా, లేదంటే గవర్నమెంట్ మీద కేసు ఫైల్ చేయాలా? గుడ్. ద sovereign immunity concept says you cannot file a criminal case on the state. In this case, if you want to file, because the person is died, it is a criminal case. If you want to file a case, file the individual criminal case on this person X. But in any case, you cannot file this case on the state. Suppose, what about the civil cases? I will tell an example. Suppose there is a person, there is one, he is running one factory, okay? The factory is about the urea factory, some chemical factory anukondi, okay? Urea kaadu, some chemical factory. So oka fine morning ఏమైందంటే the fumes are released from this factory and spread over the village, right? The fumes are spread over the village. So villagers oka roju 4 AM ki paiki lecharu, right? And the person, oka person, he want to, because village life starts early, so the person he tortured matchstick. So hotel run చేయడానికి అని చెప్పి పొద్దున్నే 4 AM లేచి, because he cleaned every utensils and matchstick రాసేసి so స్టవ్ వెలిగిద్దాం. So the fumes was burned, blasted. Okay sir, ఇది hypothetical example కాదు, it is once upon a time happened in East Godavari blood, అమలాపురం ఆ కోనసీమ బ్లోఅవుట్ కేసు, ఓకే? నియర్లీ ఎంటైర్ విలేజ్లో ఉన్న చాలామంది చనిపోయారు. సో నా ఈ కెమికల్ ఫ్యాక్టరీకి ఇప్పుడు బాధ్యత ఎవరిని పనిష్ చేయాలి? షల్ ఐ పనిష్ దిస్ కెమికల్ ఫ్యాక్టరీ ఓనర్ ఆర్ కెమికల్ ఫ్యాక్టరీకి పర్మిషన్ ఇచ్చిన స్టేట్నా? ఎవరిని పనిష్ చేయాలి? సో అండర్ సోవరెన్ ఇమ్యూనిటీ you cannot file a case, criminal case, absolutely no on the state. You cannot even file a civil liability on the case court, on the state, sorry. So if you want to do anything, you can do this person only. If you want to do anything, you can do on this person only. but not on the state, because state is sovereign. You cannot punish a sovereign entity. That's why I said it looks like a rex is lex, because rex is lex is a British concept. Rex means king, king means lex means law. So king is above the law. So if king is created the law, how can law can punish the king? If that is a simple logic. If the god of birth is Brahma, then if he is giving birth, then how can death can invite him? Because he is the creator, then nothing can destroy him. So that's why king is the creator of the law. So then how law can punish the king? So I am the sovereign. Sovereign means nobody above me. If nobody above me, how can somebody punish me? That is the sovereign immunity concept. I understood. I hope you understood it. Good. So now that's why you cannot file any criminal case on the state, but you cannot file any civil case on the state. But this was diluted by subsequent court judgments. I will tell one example. This is also related to the habeas writ. The case is about the Rudul Shah versus state of Bihar. Rudul Shah versus state of Bihar. Very finest case on the habeas. I will tell the background of the case. This Rudul Shah is a person, he murdered his wife. Good. So the court found him guilty, gave the punishment. But on appeal, the High Court, this is dealt by the Sessions Court, or you can say it a trial court. Okay. But the subsequent appeal, the High Court said that he is not guilty. He didn't murder his wife. He is absolutely innocent. Ordered to release this Rudul Shah. ఎవరైతే Rudul Shah ఎవరైతే ఉన్నారో ఆయన రిలీజ్ చేయమని హైకోర్టు ఆర్డర్ చేసింది. But instead of releasing this person, he was incarcerated, means he was jailed for literally 14 years. రిలీజ్ చేయకపోగా 14 years జైల్లో ఉంచారు. సో ఆఫ్టర్ 7 to 8 years అయిన తర్వాత దిస్ వాజ్ ఎక్స్పోజ్డ్ టు పబ్లిక్. సో one person filed a petition, habeas writ. This Rudul Shah was ordered release, but he is not released. He is illegally confined by the state police. So order that person, this Rudul Shah, before the court. So the Supreme Court ordered the state personnel of the Bihar, the police of the Bihar, to produce this person to the court. So the Rudul Shah was produced before the court. Now Supreme Court again, why he was illegally detained this much time? Arguments untai kada. So the state said that, sir, we try to release this person, but this person is mentally unsound, because he is mentally disturbed person. So to ensure the safety of this person, we are jailed him for this time. But the state district hospital civil surgeon report shows that he is mentally fit person. He don't have any mental disabilities. బట్ స్టేట్ యూజింగ్ దీస్ మెంటల్ అనే కార్డు ఉపయోగించి దట్ పర్సన్ని 14 years జైల్లో పెట్టింది. గ్రేవ్ ఇంజస్టిస్. సో నౌ it's clear that the police used their powers in negative manner and interrogated that person for 14 years long. That's a hell of the life, right? So now the Supreme Court ki dilemma ఏంటంటే now ఎవరిని పనిష్ చేయాలి? Shall I punish the prisons DG, Director General, or shall I punish the state itself? Because you cannot punish the state. You cannot also punish the state from under the civil liability also, right? So Supreme Court diluted this sovereign immunity concept. See, Supreme Court ఏం చెప్పిందంటే, see the state of Bihar, you can see it. Literally ఒక పర్సన్ని 14 years జైల్లో పెట్టారు. దట్ హ్యూజ్ లాస్ ఎ పర్సన్, ఆల్మోస్ట్ లైఫ్ ఖతం 14 years అంటే. దిస్ ఈజ్ నాట్ ఎ మిస్టేక్ టు రెక్టిఫై. దిస్ ఈజ్ ఎ గ్రేవ్ ఇంజస్టిస్. You cannot hide yourself under the behind the wall of this sovereign immunity concept. So this is sovereign immunity so that nobody can punish me. You cannot say like that, because you literally snatched 14 years of a person's life, so that you need to pay compensation of that time. This is the oldest case. I think it is 1983 or 84 case. This Rudul Shah, 1983 or 80. That time the court levied at least you need to pay the 10 lakh rupees for him. So now you can understand sovereign immunity concept in conclusion. I mean in summary. You cannot file criminal case on the state. You cannot file the civil damages. You can ask the civil damages from the state. Good, fair enough. I hope you understood the habeas corpus writ. So now you can, from the prelims perspective, you can remember the facts. So first one, purpose, illegal detention, okay. సో లోకస్ స్టాండే, నేను చెప్పాను లోకస్ స్టాండే అంటే ఏంటో. సో లోకస్ స్టాండే అంటే వాట్ ఈజ్ యువర్ రిలేషన్షిప్ విత్ కేస్. ఎవరైతే పర్సన్ సఫర్ అయ్యారో వాడే కేసు పెట్టాలి. సో దట్ ఈస్ ద లోకస్ స్టాండే. లోకస్ స్టాండే మీన్స్ వాట్ ఈజ్ యువర్ రిలేషన్ విత్ ద కేస్. ఇఫ్ యూ డోంట్ హ్యావ్ ఎనీ లోకస్ స్టాండే దెన్ యూ కెనాట్ ఫైల్ ఏ కేస్. ఎవరో రోడ్డు మీద వెళ్ళిపోయాడు, ఎక్కడో ఒక మర్డర్ జరిగింది అనుకోండి, ఆ మర్డర్ జరిగి ఇద్దరి మధ్య కొట్లాట జరిగింది, ఓకే. ఆ ఇద్దరి మధ్య కొట్లాట జరిగింది అనుకో, either this party can go to the court, this party can go to the court. I mean police complaint ఇచ్చి కోర్టుకి వెళ్ళాలి. సో థర్డ్ పర్సన్ కెనాట్ గో టు ద కోర్ట్. సో కోర్ట్ కెన్ ఆస్క్ యూ what is your relationship, what is your locus standi. So in this case, in this habeas writs, because the person is already in jail, so he cannot move to the court. That's why locus standi is diluted in this habeas. This is all about habeas corpus, right? And against whom, ఎవరికి అగెనెస్ట్గా ఇష్యూ చేయొచ్చు. It was against issued to public authorities. Important one, you can remember it. It against issued the private individuals also. Sir, ఎలా ప్రైవేట్ ఇండివిజువల్స్ ఏంటంటే ఇది ఎలాగా? Suppose I am a person working in some IT company, right? So now this IT company illegally detained me. They closed the doors. Not allow me to go home. Detention. So my wife or my children or my relatives can file against this person because it is not a public company, so that's why it's private individual or private authority. Okay, good, fine, fair enough. So now see, not issued, this is important. Okay, it is not issued about in case of lawful detention. I told you under article 22 punitive and preventive detention. Preventive detention, suppose somebody booked under the Gundas Act, okay, or else Rowdy Sheets Act, rowdy sheeters, under rowdy sheeters, so you are legally detained, preventive detention. No, you cannot ask the high court about the habeas. Good. So also you committed a crime, so the court made you guilty, I mean the court proved the guilty. Okay, so you are living in jail, that is called punitive detention. In case of punitive detention, you cannot claim the habeas writ. Good. Suppose in case of remands, judicial remand, ఆల్మోస్ట్ చాలాసార్లు మీ పేపర్లో చూస్తున్నాను 14 రోజులు జుడిషియల్ రిమాండ్, బికాస్ దట్ ఈస్ బిఎన్ఎస్ఎస్ సేస్ 14 days రిమాండ్ టర్మ్, ఆ తర్వాత రెన్యూ చేసుకోవాలి. ఓకే, ఇన్ కేస్ ఆఫ్ రిమాండ్. ఓకే, రైట్. సో ఇన్ కేస్ ఆఫ్ కంటెంప్ట్స్, contempt of court or contempt of legislature, contempt of court or contempt of legislature, in these cases you cannot ask habeas corpus to issue. Okay, because it is lawful detention, these are. Good. So shall we move to the second, mandamus? What is a mandamus? It is a mandamus. Literal meaning, I don't care about the literal meaning, but for the sake of understanding, you can understand. We command. We means people. Command. Commanding whom? Commanding the authorities. For what? To do a thing or refrain to do a thing. సో ఇది చెయ్యి అని కమాండ్ చేయొచ్చు, ఇది చెయ్యొద్దు అని కూడా కమాండ్ చేయొచ్చు. గుడ్. ఇక్కడ వరకే బుక్స్లో ఉంటుందా, బట్ దట్ ఈజ్ నాట్ అవర్ మోటో. వీ నీడ్ టు గో బియాండ్ ద బుక్స్, కన్వెన్షనల్ బుక్స్. లెట్స్ సీ. So I think habeas writs are clear to you, right? So that is all about the habeas. Now mandamus, the authorities. You are asking the authority, sir, ఇది నాకు చెయ్యండి లేదా ఇది చెయ్యొద్దు, right? Suppose ఈ చెయ్యండి చెయ్యొద్దు అనేది దట్ మస్ట్ బి ఏ డ్యూటీ ఆఫ్ ది అథారిటీ. అదర్వైజ్ యూ కెనాట్ కమాండ్. హౌ వెన్ యూ కమాండ్, సపోజ్ యూ గేవ్ 1,000 rupees to a person and after he said that, ఈ పర్సన్ ఏం చెప్పంటే ఐ విల్ పే ఆఫ్టర్ 10 days. So now after 10 days you can command this person to return it back, but this 100 rupees not a, you didn't give him on return basis, just you said that just keep with you, utilize. Now it is a gift, so you cannot command in this case. నువ్వు అప్పుగా ఇచ్చుంటే కమాండ్ చేయొచ్చు, పర్టికులర్ టైంలో ఇచ్చేయండి తర్వాత అని చెప్పి, బట్ ఆడ అడగలేదు, బట్ నువ్వంతటి నీకే వెళ్ళి ఇచ్చిందావు. సో నో, ఇన్ దిస్ కేస్ యూ కెనాట్ కమాండ్. So that's why you can see in authorities there are two type of duties. First duty is legally mandated duty. Second one is called discretionary duties. Discretionary duties. The mandamus applicable in the legally mandated duties, you cannot whatsoever command to do discretionary duties. Understood? Clear? I will tell one example. Suppose, hypothetical example, suppose this person is MRO or Tehsildar, right? Under AP Disasters Management Act, ఫ్లడ్ వచ్చింది. ఓకే, సో పొలాలు, ఈ ఏరియాలో ఉన్న పొలాలన్నీ కూడా ఫ్లడ్తో మునిగిపోయాయి. సో ఏపీ డిజాస్టర్ మేనేజ్మెంట్ యాక్ట్ ఏం చెప్తుంది? హైపోథెటికల్ ఎగ్జాంపుల్, నాట్ రియల్ ఎగ్జాంపుల్. ఓకే, సో ఏపీ డిజాస్టర్ మేనేజ్మెంట్ యాక్ట్ ఏం చెప్తుందంటే, సో ఎంఆర్ఓ కెన్ గో టు ద ఫీల్డ్, విజిట్ ద ఫీల్డ్ అండ్ analyze the field and decide the compensation, నష్టపరిహారం ఎంతో డిసైడ్ చేయాలని. ఓకే, సో దట్ డిజాస్టర్ మేనేజ్మెంట్ యాక్ట్ సెడ్ ఓన్లీ దిస్ థింగ్. సో ఎక్కడైనా వరద ప్రాంతాల్లో లేకపోతే పంట నష్టం జరిగినప్పుడు, సో అక్కడున్న ఎంఆర్ఓ, పరిసర ప్రాంతాల్లో ఉన్న ఎంఆర్ఓ ఆ ఫీల్డ్ దగ్గరికి వెళ్ళాలి. ఆ ఫీల్డ్ దగ్గరికి వెళ్ళిన దాన్ని అనలైజ్ చేయాలి. అనలైజ్ చేసిన తర్వాత నష్టపరిహారం ఎంత డిసైడ్ చేయాలి. సో దాని అకార్డింగ్ టు దట్ ద స్టేట్ గవర్నమెంట్ కంపెన్సేట్ ద ఫార్మర్, నష్టపరిహారం అనేది ఇస్తుంది. బట్ దిస్ అనలైజ్, దెర్ ఈజ్ నో ఫిక్స్డ్ టైం ఫ్రేమ్, రైట్? సో సపోజ్ ఒక 2025లో నష్టం జరిగింది అనుకోండి. యూజువల్లీ ద రూల్ సెట్ దట్ ఎంఆర్ఓ మస్ట్ కండక్ట్ ద సర్వే విత్ ఇన్ 30 days. ఓకే, సపోజ్ ఈ 30 days తర్వాత రావట్లేదు అనుకోండి, దెన్ యూ కెన్ ఆస్క్ ది mandamus. బట్ 1 to 30 daysలో ఏ రోజున రావచ్చు, దట్ ఈస్ ద డిస్క్రిషన్. ఫర్ దీస్ 30 days you cannot literally command him. I hope you understood the discretionary power and legally bound duty. Discretionary powers lo you cannot ask the person to perform the duty, because you are not at all in a position to command that person, but that is a discretion. But legally mandated duty you can absolutely command. Good, fair enough, right? So I will tell one case example. That case is all about the AK Roy versus Union of India 1982. In this case, Supreme Court said that you cannot ask the mandamus to a central government to make constitutional amendment. You cannot ask the central government. Suppose Article 16 reservations ఉన్నాయి. They are Article 16 Clause 4 is an enabling provision. Okay, you cannot claim the right to reservation in the promotions. That is enabling provision. There is a Nagaraj test అని ఒకటి ఉంటుంది. సో ఆ టెస్ట్ని ఫుల్ఫిల్ చేస్తే దెన్ యూ కెన్ eligible for the state can give the reservations. Otherwise the state cannot give reservations in promotion by default. So Article 14 is not a right to right, it is an enabling provision. So you cannot ask the central government. So suppose you are frustrated, ఆర్టికల్ 16(4) ఎనేబులింగ్ కాదు, సో ఇట్ మస్ట్ బి ఏ రైట్ అవ్వాలి అని చెప్పి. సో యూ కెన్ గో టు సుప్రీం కోర్ట్ అండ్ ఫైల్ ది mandamus అండ్ ఆస్కింగ్ ది సెంట్రల్ గవర్నమెంట్ టు amend this. So Supreme Court said that in this case, AK Roy case, you cannot do this. You cannot command the central government to do a particular constitutional amendment, good, or to enforce a particular law. Enforce a law. I will tell the example for this also, because examples are lifeline. Without examples you can't learn nothing. So I will tell an example, that is labor codes. లేబర్ కోడ్స్ యాక్చువల్లీ 2020లో చేశారు. యాక్చువల్లీ చాలా ఉండేవి, 4 వాటి కింద వాటిని మెర్జ్ చేశారు. ఎర్లియర్ ఇండస్ట్రియల్ డిస్ప్యూట్స్ యాక్ట్, ట్రేడ్ యూనియన్స్ యాక్ట్ 1920, మెటర్నిటీ రిలీఫ్ యాక్ట్, మెటర్నిటీ బెనిఫిట్ యాక్ట్, ఈక్వల్ రెమ్యునరేషన్ యాక్ట్. ఓకే, అలా ఒక 47 వరకు ఉండేవి. సో దే క్లబ్ అండర్ ది 4. కోడ్ ఆన్ వేజెస్, ఓకే, ఇండస్ట్రియల్ రిలేషన్ కోడ్, ఓకే, రైట్, కోడ్ ఆన్ ఆక్యుపేషనల్ హెల్త్ అండ్ సేఫ్టీ, ఓకే, అండ్ కోడ్ ఆన్ benefits something, okay. So now these 4 laws from the 20. So the labor code on wages లో ఫస్ట్ దాంట్లో ఏమని ఉంటుందంటే, సో the law can come into the force the date notified by the central government through the president అని. సో సపోజ్ రీసెంట్గా 2024 నుంచి అమల్లోకి వచ్చేది. సో 2020లో చేశారు కదా, మరి 2024 వరకు ఎందుకు? సో యూ కెన్ ఇంప్లిమెంట్ ఫ్రమ్ ది 2021 అని చెప్పి యూ కెనాట్ ఆస్క్ mandamus టు ఎన్ఫోర్స్ దిస్. దట్స్ ది కేస్ సెట్ దట్ యూ కెనాట్ ఆస్క్ ది సెంట్రల్ గవర్నమెంట్ టు డూ ఏ పర్టికులర్ కాన్స్టిట్యూషన్ అమెండ్మెంట్. యూ కెనాట్ ఆస్క్ ద లా టు ఎన్ఫోర్స్, రైట్? ఫెయిర్ ఇనఫ్, గుడ్. నెక్స్ట్ కేస్ ఏఆర్ జక్కీ. మీరు ఎలా గుర్తుపెట్టుకుంటారో నాకు తెలియదు, ఇట్లా గుర్తుపెట్టుకోండి, ఓకే. ఏఆర్ జక్కీ కేస్, ఆర్ యూ కెన్ సే స్టేట్ ఆఫ్ జమ్మూ కాశ్మీర్ అండ్ ఏఆర్ జక్కీ వర్సెస్ ఏఆర్ జక్కీ. ఏఆర్ జక్కీ, గుడ్. సి వాట్ ఈస్ దిస్ కేస్ ఈజ్ అబౌట్? దిస్ కేస్ ఈజ్ అబౌట్ దిస్ జక్కీ ఈజ్ ఏ కోర్ట్ assistant in J&K High Court. So this person is a assistant in Jammu Kashmir High Court. So this person along with the readers of the court, okay, assistants of the court, ఒక రోజు ఏం చేశారంటే, దే గో టు ద చీఫ్ జస్టిస్ ఆఫ్ ది హై కోర్ట్ అండ్ టోల్డ్ ద గ్రీవెన్స్. ఆ గ్రీవెన్స్ ఏంటి అంటే, ఈ రీడర్స్కి, ఈ ఆఫీస్ వర్కర్స్కి, అసిస్టెంట్స్కి, వీళ్ళకి దెర్ ఈజ్ నో ప్రమోషన్ ఛానల్. లిటరల్లీ దే ఎక్కడైతే ఉంటారో సో అక్కడే ఉంటారు లైఫ్ లాంగ్. సో దెర్ ఈజ్ నో ప్రమోషన్ ఛానల్, సో దెర్ ఈజ్ నో కెరీర్ గ్రోత్ ఇన్ దీస్ సర్వీసెస్. సో దే వెంట్ టు ద చీఫ్ జస్టిస్ ఆఫ్ హై కోర్ట్. దో సెడ్ దట్ అట్లీస్ట్ బికాస్ మాకు అసలు ప్రమోషన్ ఛానలే లేదు, సో మేము ఎక్కడ స్టార్టింగ్ స్టేజ్ ఎక్కడ చేయనా లైఫ్ లాంగ్ అక్కడే సర్వ్ చేయాల్సి వస్తుంది. సో జస్ట్ ఆన్ ది హ్యుమానిటేరియన్ గ్రౌండ్స్ కన్సిడర్, ఓకే, కన్సిడర్ యాజ్ ప్రమోట్ ది బాగా సీనియర్స్ని ప్రమోట్ చేయండి. ఎలా యూ కెన్ అట్లీస్ట్ ప్రమోట్ యాజ్ అ మున్సిఫ్ ఆర్ జడ్జెస్, ఓకే, సివిల్ జడ్జెస్ కింద వాళ్ళ కింద ప్రమోట్ చేయండి విత్ హ్యావింగ్ దీస్ పీపుల్ హ్యావింగ్ లా డిగ్రీస్, ఓకే, దీస్ పీపుల్ హ్యావింగ్ లా డిగ్రీస్ సో దట్ యూ కెన్ మేక్ దమ్ యాజ్ ఏ జడ్జ్ ఆర్ సివిల్ జడ్జ్ ఆర్ మున్సిఫ్. సో చీఫ్ జస్టిస్ ఆఫ్ హై కోర్ట్ జమ్మూ కాశ్మీర్, yeah, it's a good grievance, genuine grievance, so he agreed and said that 20% 20% jobs or promotions reserved for these people. Okay, obviously the judiciary is not to make laws, so these proposals sent to the state of Jammu Kashmir. The state of Jammu Kashmir denied act, దీని లా చేయమని చెప్పారు, బట్ దే ఆర్ నాట్ యాక్టింగ్ ఎనీథింగ్. సో these persons went to J&K High Court, asked for the mandamus to command the state legislature to make a law, so that they can get these 20% promotions exclusively reserved for them. State government agreed, issued J&K government, so make this law. So the J&K government went to Supreme Court. So Supreme Court cancelled this. Supreme Court favored the state government and said that the mandamus cannot issue to a state legislature or legislative bodies to ask them to enforce a law or to enact a law. Good? Now you understood the mandamus. So mandamus cannot be issued against the legislature. So mandamus can be issued against the administration, means executive, but executive in the field of discretionary powers cannot be issued, right? In legally mandated, legally bound duties it is issued, but discretionary it is not issued. But this distinction is also removed now, because Supreme Court said that there is no discretionary powers. First of all, if you are using a power as a discretionary power, that is arbitrary, so you can be issued with mandamus. So administrative bodies can be issued as a mandamus, right? So now summary. See the summary. So against whom? Against executive. Executive, right? So right, next, not issued against private individuals, because the private individual is not your servant. So if he is a servant, then you can command. If he is not a servant, how can you command? That is the logic. So next, it is not issue to enforce the departmental instruction. What is departmental instruction? Right? So suppose there is a department, suppose there is an electricity department, AP Transco, okay? There is electricity department. So there is some notice in this electricity department. So from today onwards, these things can be done. So you cannot ask the mandamus to enforce this notice, departmental instruction, right? That is departmental instruction, right? Next, it is cannot issued purely in discretionary matters. In the it is purely discretionary. Then you cannot ask, command. You cannot command. Right? Next, very good point. You cannot ask against president, governor, or CJ acting in judicial capacity. Right, ఓకే. సో చెప్పాను కదా, మై డ్యూటీ ఈజ్ నాట్ టు రైట్ దీస్ వర్డ్స్ అండ్ దిస్ హ్యాపెండ్, దిస్ మస్ట్ హ్యాపెన్. I didn't like that way a kind of teaching at all. So now I am asking, why you cannot issue a mandamus to the president or the governor, or you cannot ask a CJA acting in judicial capacity, means because he is acting in judicial functions. Okay, why you cannot issue against a writ, mandamus writ cannot be issued against under president or governor? Think. Because the president or governor, they can do duties, discretionary duties, legal duties, I mean constitutionally bound duties, right? They both can do these two. Governor discretion is obviously greater than the president. So if they are acting in discretionary manner, you cannot comment, because discretionary matters ki mandamus applicable kaadu. If they are acting a legal functions, in this case also you cannot issue. Why? Because they are acting under the guidance of central government, cabinet or state cabinet. Because they are acting under the central government or state government cabinet direction, literally you can ask these people, not this person, because these people are doing that. The president is just giving the assent or governor is giving, extending his or her assent. But the real funda is lying with the central government or state government, because the state government, the president act on aid and advice of the cabinet, same with the governor also. But in case of discretionary matters, your channel is closed, you cannot go ask the writ jurisdiction. That's why in this case you cannot enforce the mandamus against the government. You cannot ask the CJA also. Why CJA also? Because it is judicial function, right? If the judicial function is you are dictating what to do and what not to do, right? Because you are just diluting the role of the CJA as a master of the roster. Because you are asking a mandamus, suppose you are asking a mandamus, suppose the roster CJA ఏం చేశారంటే, సపోజ్ శబరిమల కేసు ఉంది అనుకో, సపోజ్ శబరిమల ఇట్స్ రివ్యూ పిటిషన్ నడుస్తుంది కదా. సో శబరిమల కేసు అది ఇట్ ఈస్ ఎర్లియర్ 7 judge bench అనుకోండి, నా రివ్యూ పిటిషన్ మస్ట్ బి గ్రేటర్ దెన్ దట్. సో ఏ 9 judge bench అనుకున్నాం. సపోజ్ యు ఆర్ ఆస్కింగ్ ఏ mandamus, why 9, మేక్ ఇట్ యాజ్ ఎ 13 ఆర్ మేక్ ఇట్ యాజ్ ఎ 15 or make it as a whole together, all 31 bench. Because you are commanding the CJA, right? So that's why CJA in judicial manners you cannot ask them. Okay, mandamus cannot be issued. I hope it is clear to you. Nice, good. And the last two we can club together and we can read it together. So before that I will tell one example so that you can understand it better. So see, higher judiciary, Supreme Court, High Court. The layer is, next layer is subordinate judiciary, that is your district courts, tribunals, National Green Tribunal, Administrative Tribunal, okay, any quasi judicial bodies, Quasi judicial bodies like it is SEBI. SEBI is a quasi judicial body because it is an executive body as well as do some kind of judicial functions. That is called quasi judicial. It is not purely judicial, but it is a primarily an executive body, but giving some judicial powers. TROI, example, TROI also. Because TROI can regulate the telecom industry as well as TROI can impose the fines also. That is, imposing fines is a judicial function actually. So, but TROI is doing that. That's why it is called quasi judicial body. So, and Gram Nyayalayas, alternative dispute resolution, okay, Lok Adalat. So, ivanni subordinate judiciary. Good? Right. Now, I will give one example so that you can understand it much better. Okay? See this. There is a case. Okay? There is this person went to, suppose I will give one current example so that you can understand it better. Suppose this is AP Transport, okay, or you can take it as AP Genco, generation company, power generation company. So actually power generated by the Genco sold to the Transco, and the Transco will sell to the DISCOMs, distribution companies. So from the DISCOMs you will get the power to every house. So you will pay the DISCOMs electricity bill. So DISCOM will pay to the Transco company, Transco will pay to the Genco company. The problem with DISCOMs, but you cannot never hear about Transco, Genco current power, fiscal issues. You can issues DISCOMs are facing huge losses because you are paying electricity bill. The government is saying farmer paying electricity bill. So government is saying loan waiver. So no, farmers cannot pay the bills now, but government need to pay this DISCOMs. So government is also not paying. So DISCOMs is facing huge loss. So that's an altogether a different economic topic. That's why government launched Uday scheme. Okay, that is a different economic topic. So that is not our domain. So now see, there is a dispute between Transco and the DISCOMs. Good. So DISCOM need to pay 50 lakh to the Transco according to the Electricity Act. According to Electricity Act 2013. Whenever there is a dispute between these companies, corporations, the cases resolved by the Electricity Tribunal. Good. Now, this is the law. Now the Transco went to the asset reconstruction of DISCOMs. Okay. So now Transco em cheppindante, so you need to pay me 50 lakhs so that you can sell your assets and pay it to me. So they go to insolvency and bankruptcy code kinda, so they went to the court. So the court said that insolvency and bankruptcy code, okay, the DISCOM need to pay the sell the assets and give back the money 50 lakh to the Transco along with 10 lakh fine. Now these DISCOMs went to High Court under 32. They can go to two stages. First one is prohibition. So now they are asking that High Court, according to the Electricity Act, that these type of disputes listened by the electricity tribunal, but not by these insolvency and bankruptcy courts. Not the insolvency and bankruptcy courts cannot entertain this matter. So it is violation of Article 32. It is a violation of the fundamental right. So because you can you can order under the prohibition. So now on the prima facie, High Court will issue prohibition and ask the court under the insolvency and bankruptcy, it is not your jurisdiction, so you cannot entertain this case, so transfer it to me, because subordinate tribunal is a subordinate, High Court is a higher judiciary. So now you can transfer it to me. Cool. It is this prohibition in case applies during the trial. And suppose this DISCOM went to the court during the trial listening of this case, but once this case is listened and they gave the judgment, then also they can go to the court, right? That is certiorari. Good. Certiorari, once the judgment is issued, then you can ask it, this judgment cancel, and you can transfer this case altogether, because this judgment is, because you are not competent to listen it, then how can you pass the judgment, right? If you are a police constable, right, then how can you perform the duties of the CI? Because your duties are limited, his duties are limited. This is not your territorial jurisdiction, then how can you this is not your jurisdiction, then how can you entertain extra jurisdiction? That's a excessive jurisdiction. You are encroaching other jurisdiction, so you cannot do that. So transfer this case. Your judgment is wrong. Good. So that's why prohibition is curative also. Good. So now see, I understood this prohibition and certiorari. The difference is that in this case, in prohibition, whenever there is excessive jurisdiction, because this case, in this example, this case is listened by the electricity tribunal, but it is listened by the other courts, so that's why it is excessive jurisdiction. But in certiorari, apart from the excessive jurisdiction, there is an involvement of error of law. What is this new issue? Again, so because certiorari decides the judgment also, it gives the judgment also, because prohibition is ఎప్పుడు ఇష్యూ చేస్తారు, జరుగుతున్నప్పుడు ఇష్యూ చేస్తారు. సో బట్ certiorari issued after the judgment, so that way there is an error of law also. Good. That's why prohibition is excessive jurisdiction ఉన్నప్పుడు, but that's why it is curative also. I hope it is clear to you. Because why this error law will happen? Because it may happen because there is a principles of natural justice is violated. Suppose there is a famous one of the rule of the principle of natural justice is ad altrum partem, means listen the other side argument. That means listen the other side. Okay, you cannot decide the case unanimously, you can listen the other side also. Suppose this is a violated, there is error of law also happen. Okay, Because when there is a jurisdictional accession, error of law also happen, because you cannot implement this law, then how can you use that law and charge the punishment? So that's why this prohibition only on the ground excessive jurisdiction, but this is applicable to error of law also. Good, right? So and last one is called, so that you can wrap up for today, quo warranto. Quo warranto is asked by anyone. That's why locus standi is absolutely zero. Anyone can ask anybody. Quo warranto means what the authority or warrant, authority or warrant. See, one example. This is a person, this is a hospital. He is having a law degree, but appointed as a doctor. Ridiculous, absolutely ridiculous. If you are having law degree, then how can you are appointed as a doctor? So in this case, you can ask you have a doubt, because that person is having law degree and he is performing doctor profession, so that you can ask the government. This is a government hospital, not private hospital. So you can ask the person, ask the state, how can this person hold this doctor, district doctor position? By what authority or warrant this person hold this doctor position? Basically, this is about educational qualification. It is asked about the qualifications only, not issued for the competence. I hope you understood what is a competence and qualification. Suppose, take this case, this is government hospital, this is a doctor position. This person is a doctor having MBBS degree, but this person is a very lazy person and escapist, cannot perform surgeries very well. Can you ask in this case the quo warranto? Absolutely no. Because you cannot ask the competence of the person, you can ask the educational qualification. Right? That's why you cannot, this quo warranto cannot applicable to ministerial offices, ministerial duties. You cannot ask that person, because constitution gives certain qualification. You need to be elected, at least you need to have 30 years of age, okay, so that you can participate in election. If you win the election, then you can become the cabinet minister if CM wants or PM wants. That is the qualifications. If you fulfill that, then it is absolutely valid. You cannot ask the person, the quo warranto, because it is not about the competence, it is about all about the qualification only. If you have fulfilled your qualification, then absolutely you are free. If you are not qualificational level, then you can ask that issue, you can ask to issue the quo warranto. But you cannot issue to ask for the competence. Ni competence ledu kabatti you cannot hold that position. No, you cannot say that. I hope you understood this. Good. Suppose, yeah, another example, you can take any example. Suppose there is a private office. A private office even didn't come under the ambit of quo warranto, because quo warranto is issued only for the public authorities. Because see the logic why private bodies is not under this ambit, because a public office is indirectly managed by the public taxes. The personal attendance or every working personnel paid by the taxes, because taxes are pooled by the public or paid by the public. So that is the taxes, the people's money indirectly, because that is the people, there is a right for the people. But in case of private, the private entrepreneur is making the money. Suppose he is taking the person, incompetent person, then it is literally lost to this person only. There is no much hue and cry for the public, right? So that's why these private offices are not under the ambit of the government. But there is a caveat. There is a statutory bodies. Then like ONGC, GAIL, SAIL, BHEL. These are the statutory bodies in this case, because it is not purely government bodies, nor purely, because they have financial autonomy like that. Navaratna companies. In this case also, they fall under the Article 12 states instrumentality. Ajay Hasya versus Khalid Muzib case. If these statutory bodies comes under the Article 12, then you can ask for the quo warranto. Good, right? Fine. So these are the 5 types of writs. So you can ask at the relevant things. For illegal detention, you can ask habeas corpus. To do a thing or not to do a thing, you can ask the mandamus. If there is excessive jurisdiction or plus violation of law, then you can ask for the prohibition certiorari. In case of illegal or not having qualification to hold the job, then you can ask quo warranto. I hope it is clear to you. So these are the 4 things. So in this case, court must take. In this case, court must accept. In this case, court must accept your petition. In this case, the court can either accept, can reject. It is a judicial discretion. Okay, judicial discretion. Good. So this is about the 4 type of writs, right? Okay. Now tomorrow we can understand, maybe day after tomorrow, doctrine of basic structure. Why the doctrine of basic structure is evolved? There is a tussle between government and judiciary about the fundamental rights and DPSP. In some cases, fundamental rights are supreme, so judiciary said fundamental rights cannot be violated, and government bring a amendment. Now there is a case again, Supreme Court held that fundamental right is supreme. Again government come up with another constitutional amendment. So there is a tussle happened, government and judiciary, especially the fundamental rights and the DPSP right to property versus right sorry uh, uh, equal distribution of resources, the EPS. So there is a, because the problem is all about the right to property and socialism principles. How can you take my property? Because right to property that time was a fundamental right. That there is a hue and cry led to the first constitutional amendment, 7th constitutional amendment, 17th amendment, 42nd amendment, finally 44th amendment removed the right to property as a fundamental right. So there is the tussle is so much severe between the government and judiciary. So finally there is a middle path issued by the judiciary in the Keshavananda Bharati case 1973. Okay, good. So that was a middle path. That is not a pro stance. Actually, that was a middle path that balanced the government Article 368 powers and the essence of the fundamental rights. Okay, good. Actually, the DBS, Doctrine of Basic Structure, is a German constitution innovation. That is not a German constitution. Actually, because in the Germany there is the court's duty is not interpretation of law. The court duty is just to give the punishments, judgments. Because in Indian constitution the court can interpret the constitution also, but in Germany the constitution cannot. The courts cannot interpret the Weimar constitution. That is, Weimar constitution is German constitution. So they cannot interpret the Weimar constitution. The duty of the interpretation of the constitution in Germany lies with the legal scholars. Right? One of such scholar that gave the doctrine of basic structure, that basic structure doctrine, listened, that person, I will tell that person tomorrow. Okay? So that person attended Banaras Hindu University. He gave a lecture. That lecture was listened by the Fali Nariman, one of the finest judge in India, and Fali Nariman and other Chandrachud. So these people influenced by these DBS concept, and they started applying it to India. Okay, good. So tomorrow we can, or day after tomorrow if possible, so we can understand the birth of the doctrine of basic structure. Why? Because there is two things that merged under one head. First one is fundamental rights versus DPSP, that is one channel, and Article 368 versus fundamental rights essence. These two clubbed under at the time of Golaknath. Okay, and emerged as a one issue till 1973, doctrine of basic structure. Okay, good. So tomorrow we can understand these genesis of the DBS and why its applicability, what is the contents, or what are the ingredients of the basic structure. We can understand it tomorrow. So I hope it is clear to you. Okay, with these you can go to your previous year questions and just try to answer those questions. Okay, take care, have a great day.